Special thanks to Bryce and his team for coming together and pulling this presentation together for us. I was fortunate enough to spend half an hour last Thursday just talking with Bryce's team around funerals and the impact of COVID on funerals, and out of that came the discussion around this short session today. So thanks to Bryce and Gemma and team for making themselves available for this. So I did circulate a bio on Bryce earlier today, but just welcome Bryce. Bryce is the partner at Gibson, Sheat in Lower Hutt and looks after the estates and elder law team. So I thought that was lovely synergy with our business, and we talked briefly the other day just around the challenges that we have with estates, particularly at this time of the year with COVID, and I thought he could just talk us through a short presentation on some little tricks that perhaps he has up his sleeve, and just around the process of probate and letters of administration. So Bryce, over to you. Thanks again.
Thanks, Gavin, and again, thanks for the opportunity for Gemma and I to present to you this morning. Gemma is a solicitor in our Elder and Succession Law team, and so we'll be co-presenting this morning. I'd also like to acknowledge that this is a particularly challenging time for your industry, and so just to say again, thank you to the wonderful service that you guys are providing to our community. And I know that this is extremely distressing for family and friends being unable to gather to celebrate a loved one's life and to grieve. So hopefully the government will be able to provide some greater clarity on things going forward in the next few days. Today's presentation is really designed to help you understand the estate administration process better and to field any questions that you may have. So we're going to be covering quite quickly the following topics: powers of attorney, executor's duties, rights of burial and cremation, probate, letters of administration, winding up of estates and the order of distribution, and last but certainly not least, payment of funeral accounts. We expect that will take about 20 minutes, and after that there'll be definitely time for some questions. And as you're probably aware, there's a 40-minute time limit to these Zoom meetings, so hopefully we don't get cut short. But to kick off, in terms of powers of attorney, a power of attorney is a legal document which allows someone to appoint someone to make decisions on their behalf or administer their affairs. And the simple point is that these documents only apply while someone is alive. So when someone passes away and they've granted a power of attorney, whether it be a standard power of attorney or an enduring power of attorney, when that person dies, that power comes to an end. The attorney has no legal authority or right to do anything when someone's passed away. The main difference between a power of attorney and an enduring power of attorney is that standard power of attorney allows a person to act on someone else's behalf when they have mental capacity. But if that person loses mental capacity, then the attorney has no authority to do anything. In contrast to that, an enduring power of attorney endures. That's why it's called an enduring power of attorney. Allows the attorney to continue acting if the person who appointed them loses mental capacity, and that's been assessed. So I just thought it's important just to touch on that, because from time to time you might have people come to you and say, well, I'm the person's attorney, and purport to act on a deceased person's behalf when they don't have the authority to do so. And Gemma's going to now touch on executor's duties.
Thanks, Bryce, and good morning, everybody. Nice to see you all this morning. So we know what an executor isn't. But in terms of what an executor is, I'm sure you're well aware. It's the person that's appointed in somebody's will to take care of their affairs. And from a legal perspective, there's a list of duties that an executor has to follow. The first one you're probably very familiar with, which is their responsibility for the funeral arrangements. But further than that, they are responsible for gathering in the estate assets, for dealing with any estate claims, for the payment of debts, funeral and testamentary expenses, and then down the track they are responsible for dealing with the distribution of the estate, including gifts and legacies, and then a final distribution on whatever terms the will provides. You may come across a scenario where an executor is appointed in a will and they either are unable to or unwilling to act. There can be some questions and uncertainty around this. It is possible for an executor to renounce, ideally where there's two appointed at the same time, or there's an initial one and then a successor. That makes the process fairly smooth for us to manage. So if somebody does not want to take on that role, that can be dealt with. It also is provided for in legislation that if an executor doesn't apply for a grant of probate within 90 days, and a grant is required, that somebody else can make that application instead. So we should never be stuck with estates that need to be managed and nobody's managing them, and things just fall away. There is always a process to follow if need be. And I'll just mention an example there. We've acted for creditors who have outstanding debts from an estate, and we've helped them apply for somebody else to be appointed as administrator to get those debts paid. In terms of executors and trustees, you often see that word used interchangeably. So if somebody talks to you and says that they're a trustee, most likely they're also an executor. The will refers to those two interchangeably, and they're one and the same, but they have different roles. So initially a person takes on the role as executor and follows those duties that I just mentioned. And once they've, for example, gathered in the estate assets, they hold them on trust for the beneficiaries of the trust, and that's where duties of trustees come into play. And we've got an estate administration brochure that I believe Bryce provided to Gavin. So that's really helpful in setting out the executor and trustees' duties and how they differ. And if you haven't already seen that, I would encourage you to do so. It's very helpful and very easy reading. I also wanted to just touch on the rights of burial and cremation as another topic. You probably have more experience in that area than I do. We often as lawyers don't necessarily see that side of things unless there are huge disputes around burial of bodies, and mostly things can be dealt with from a practical measure, which is good. But in terms of who has the authority and who has the right to make decisions, ultimately it's the executor. So if you are receiving different instructions from different family members or different opinions, absolutely hear them out. It's such a tough time for them to deal with, but ultimately your authority comes from the executor. We would hope that there wouldn't be disputes and that the executor would also take into account what the family members want to do. But the court has gone so far as to say that where there are disputes, an executor takes, their authority is higher than a surviving spouse, for example. So the courts are very clear that it's the executor that makes the final decision. In terms of where there isn't a will, that can create some more difficulty. Who has the authority? In usual practice, it would be the next of kin, so a family member to make those decisions. Where there are arguments or disagreements among family members, the question then becomes who has higher authority. And there's case law to suggest that it would ultimately be the person who has the greatest claim to become an administrator of the estate. That would be the person who you would need to, take the final decision from. But again, we would hope that it wouldn't come to that, and that the families would all agree. Over to you, Bryce.
Great, thanks, Gemma. Now going to touch on the process of obtaining probate or letters of administration. So the process of probate is basically where the will of a deceased person is proved valid by the High Court. That process is required where there is real estate in a deceased person's name, in their sole name, or where it's held as tenants in common with someone else but not jointly, and or where there's an asset over the value of $15,000 because the real estate can't be dealt with, or the asset, whether it be a bank account or investment, the asset holder won't release those funds or liquidate them and release those funds unless there is a grant of probate. And it's important to know that an executor appointed under a will derives title from the will. So they're appointed under the will. That's how they are appointed. But if they have to kind of prove that they're the executor, kind of authentication of that title is probate. So it's a bit like if I said I own a house property and someone said prove it, then I produce a copy of the certificate of title or record of title. It's the same with probate. There are situations where there are small estates where the estate is less than 15,000, and in those situations a grant isn't required to deal with those assets. So it might be if there's a house that's owned jointly and then there's a small sum of money in the bank, then a grant of probate isn't required in those situations. And the say for example a bank can authorize payment to a next of kin, and there's usually a documentation that's completed for that. In terms of processing times with probate applications, before COVID, we would usually expect for there to be a 4 to 6 week period before we would get a grant of probate back. But in light of a lockdown, the probate registry was closed because it wasn't considered an essential, well, the courts are considered an essential service, but they weren't priority proceedings unless there were urgent grants required. And that's usually if there are assets that could waste away, maybe investments that need to be dealt with really, really promptly. And so, you know, the issue is that in terms of getting grants of probate through at this time, without the original will, and try and a further way of kind of dealing with things, that process is halted somewhat. Obviously with COVID and the lockdown, and even coming out of that, the processing times I would imagine are going to be considerably longer than what we're used to, but I'm sure the courts will be ensuring that they will be managing that as efficiently as they can. In terms of letters of administration, this is usually where there is no will, so someone needs to apply to the High Court to get a grant, and where there's no will, that's called an intestacy, and so the application is called an application for letters of administration on intestacy. And the High Court rules set out who has priority to that grant, and first in priority is a surviving spouse or partner, and then it goes to children and so on and so forth. And the court will will usually make a grant in favour of someone who has a beneficial interest in the estate, i.e. they're a beneficiary. The courts can pass over people who would usually be entitled if there are circumstances which suggest the court should do so. For example, the person with priority might be a bankrupt, or there might be other reasons because there is conflict within the family. But usually the court will appoint a person who has priority. And until that person is appointed, then no one has authority to administer the estate. Letters of administration take a lot longer to obtain because you have to make searches for a will, and usually there's an advertising process for that. And then you may need to get the consent of other people who have equal standing to apply. And as you will know, in families, some people get along very well and others don't. Some people are more willing to consent than others, and so there can be a delay, which is not what you want at a time like this. So it's really imperative that that all people have a will to avoid that issue. And then when it comes to distributing estates, there's usually a 6-month period from the date of the grant where claims can be notified. And so executors or administrators would usually be reluctant and would be advised not to distribute before that 6-month period, because if a later successful claim is made and they've distributed all the assets, then they will be personally liable for making good on that claim, and trying to get money out of beneficiaries when it's been distributed isn't necessarily the easiest process. So Gemma, I'm going to kick over to you to talk about winding up of estates and order of distribution, and then I'll round off with payment of funeral accounts.
Thanks, Bryce. I've only got a couple of things to say here, quite briefly, in terms of the order of distribution. The will, if there is a will, it will provide that funeral and testamentary expenses and debts are paid, which is great. And as long as that is followed, then all is well. I guess the problem that arises is where an estate has insufficient funds, and for example, there's a funeral account outstanding, and there's also a gift of $10,000 to cousin Mary, and actually the executor decides to pay that gift instead of paying the funeral account. And questions arise: can they do that? What's the order of distribution, and who has priority? So if there's a will, the will provides that those expenses must be paid before distribution, including distribution to family members or gifts, etc. Where there isn't a will, the Administration Act provides that where there's insufficient estate assets to deal with debts or expenses such as funeral expenses, the administrator can follow the priorities that are set out in the Insolvency Act. So Part 6 of the Insolvency Act has a list of who has priority to be paid out. In the first place, it's estate administration expenses, and in the second place, so second priority, is funeral expenses. So just as a reminder, you're right up there, you're number 2 on the priority list in terms of getting your accounts paid. So your account should be paid before distributions are made to family members.